Move on to the third case, which is case number 30133, also State versus Coleman, also involving attorneys Corrigan and attorney Killey. On this one, though, attorney Killey is the appellant. So same rules apply. You know them well, so we'll go right into the arguments on this.
Thank you, Your Honor. May it please the court, Attorney Angie Killey on behalf of the appellant, Charles Coleman, and I would like to reserve 5 minutes for rebuttal.
Very good.
And I guess I would say up front, I do thank the court. I did make the request to have these heard on the same day because there's so much overlap between the two of them that I wanted to ensure we at least had the same panel. And obviously, the primary argument in this instance that I raised was a speedy trial issue, but the crux of it is exactly the same. There's a slight difference in the calculations that I did to determine the number, but the reality is that it is our position that the trial court violated Mr. Coleman's speedy trial rights in this case as well, because the sua sponte continuances by the court in particular were not reasonable, not appropriate, and the defendant was prepared and asserting his rights to go forward in trial. And if the court has additional questions as it relates to that, I'd be happy to answer them, but I don't feel as though I need to re-articulate the exact same argument to the same panel of judges. So moving on from there, I think what I would like to do is focus on that I believe that whether or not Mr. Coleman had ineffective assistance of counsel during the course of his trial. There are other arguments and errors, assignments of errors that I put forth, and I am hopeful that the court will consider, but the reality of the situation is there are issues of preservation on almost all of them, and that's why I'd like to tie it all in as it relates to the ineffective assistance of counsel. One, I guess, to premise off of the argument that opposing counsel was making, if the court does feel that there was no direct objection to the sua sponte continuances by the trial court, that would be part of how counsel's conduct or performance did not rise to the appropriate level. And in particular, I think one of the issues I'd like to highlight for the court is as it relates to Reagan-Tokes and the constitutionality of that sentencing scheme. I know that when I drafted this, that we had recently had oral arguments on a case where the Ohio Supreme Court was resolving whether or not this issue was ripe for appeal because there was a conflict between the jurisdictions. The Supreme Court did rule on that in April of 2022, finding that this issue is ripe for courts to review the constitutionality of the issue. I also recognize that it's kind of a fluid area of the law because there are new regulations being considered and looked at by the Ohio Department of Corrections as it relates to this. But I'm asking the court to look at it as it took place when Mr. Coleman was going to trial and when he was being sentenced. And as it relates to him, find that this is an unconstitutional law because Reagan-Tokes does not contain the appropriate safety safeguards in regards to a hearing that a criminal defendant is entitled to under due process. In this particular instance, I will acknowledge that trial counsel did not place an objection on the record to Reagan-Tokes being constitutional or not. That's why I raise it under the premise of ineffective assistance of counsel. Because this was a fairly new law, because this was a situation where there was pending law in the Ohio Supreme Court on whether or not it's constitutional, and because of the fact the trial judge brought this up to the parties before sentencing, acknowledging that there was pending litigation in the Ohio Supreme Court, recognizing that the 8th District at least had found that Reagan-Tokes was unconstitutional in sentencing criminal defendants, that there was nothing in this jurisdiction, that trial counsel's lack of taking the hint, shall we say, and actually placing an objection on the record to preserve this properly for appellate procedure, to me, rises to the level of being ineffective on its own without even looking at any other errors that I am looking at, because this is a serious constitutional issue. And even though there can be no expectation that every lawyer knows every case that's pending, the law is constantly changing. We all know that. No matter how much we try, we can't keep up with everything. When the trial judge puts it in front of you on a silver platter and you don't even bother to put the objection or acknowledge it on the record, I would say that that's ineffective. in the basis of that. In addition to that, trial counsel did not file for a motion for a new trial, as was requested by the defendant in this case. The defendant ultimately ended up filing his own motion for a new trial, which the state is going to argue was untimely. The trial judge said was untimely. However, she did give him a full hearing on that. However, that hearing, although still represented by counsel, at least supposedly, Mr. Coleman did himself. Counsel didn't contribute to it at all. He said that he felt that Mr. Coleman was probably looking for a new attorney, but nothing happened with that. And Mr. Coleman essentially had to argue his own motion for a new trial. And that motion for a new trial brought up at least a couple of very valid points that I would like to bring up to the court. One of those being that this case, there was one witness who was never brought into court, never actually subpoenaed, never participated in any of the criminal process. That individual, according to Mr. Coleman, gave a statement that could be viewed as exculpatory. If he gave us, Mr. Coleman was effectively identified and arrested on this charge based on the color of his hoodie that he was wearing the night that he was out. Supposedly, this other witness gave a statement to the police on the night of the shooting. They was shot by somebody in a different color hoodie. When you combine that with the fact that somebody else was a major contributor to DNA on every part of the firearm that was utilized in this shooting, I think that's huge for the defendant. And that's something that his counsel failed to argue on his behalf or to bring up. In addition to that, when it came time to sentence him, a couple of sentences were thrown out there, no real arguments put forth by trial counsel. And it's pretty clear from the record that their relationship had deteriorated at this point, but that doesn't change our obligation to advocate on behalf of our clients and to try to get him a sentence that's appropriate based off of his convictions and his past history. And there's little to none of that taking place. In addition, as was also raised by the defendant in his motion for a new trial, trial counsel did kind of impugn his character while he was giving his closing argument. You know, Mr. Coleman took the stand. His credibility, his interest in the outcome, whether he's biased, those are questions for the jury. And those are things that they're supposed to be making a determination of while they're doing their deliberations to figure out whether they believe him or not. His own attorney stood up there in closing argument and told him that he was a bad witness and that he had an extreme interest in the outcome, or essentially that he was biased during his closing argument. That certainly doesn't help his situation. So I think all of those combined certainly fall below the standard of reasonableness and care that we are supposed to exercise in representing a criminal defendant. And we're talking about a fairly serious case with serious charges and a lengthy prison sentence that resulted from his conviction. I think, as I said, I think on its own that failing to object to the constitutionality of his sentence is sufficient. But with all of them combined, I think that this is a situation where he did receive ineffective assistance of counsel, and this court should reverse his convictions and submit it for a new trial. Nobody has any, yes? Anybody have any questions?
I was just going to ask the same thing. Judge Carr?
Thank you.
And Judge Callahan. All right, thank you, Attorney Kelly. You'll have 5 minutes for rebuttal.
Okay, thank you.
Attorney Corrigan, you may proceed.
Thank you, Your Honor. Again, may it please the court, I'm Jack Winnett Corrigan on behalf of the state of Ohio, this time asking this court to affirm Mr. Coleman's conviction and sentence. Just a couple of points, focusing as counsel has on whether Mr. Coleman's trial counsel was ineffective. I would remind the court that under Strickland v. Washington, there are 2 points that have to be met by the defendant to show that his counsel has been constitutionally ineffective. Not only an objectively deficient performance by counsel, but also prejudice, which means that the outcome would have to have been different in some way in the course of, calling witnesses. Would that be not a conviction, but an acquittal, or in the case of the sentence, some other sentence? And we're hearing a lot about what Mr. Coleman believes are deficiencies in his counsel's performance, but not really hearing much about the prejudice prong of Strickland. As far as the Reagan-Tokes Act, yes, indeed, the Ohio Supreme Court has found that discussions of whether that act is constitutional or not are ripe in a defendant's direct appeal. However, we never had this raised in this case. So, and no plain error is even possible, because the discussion of whether the Reagan-Tokes Act is constitutional or not is a novel issue. It has not been raised in Ohio. We would expect objectively an attorney we would objectively expect an attorney to raise the issue of its constitutionality if there had been more than a hint by the trial judge at sentencing that there may be an issue with constitutionality of it. Now, whether counsel chose to raise that or not is also a trial tactic. And I would remind the court that while a great lawyer may raise novel arguments in the trial court or even in the Court of Appeals and may try to expand the law or challenge the constitutionality of a statute, or even to take the hint of the judge, a good lawyer is not required to do that. In other words, you don't have to do all those things in order to be considered to be constitutionally effective or adequate. So
how is this a novel issue, though? It was before the Ohio Supreme Court.
Well, currently the most recent pending issue was whether this was even ripe. And it was currently, I think that what the trial court was mentioning during sentencing was that there had been some case law from a different district, but from a different district, not from the Ohio Supreme Court itself. So I'm not certain that at the time when sentencing took place, that the issue had actually been accepted by the Ohio Supreme Court. So there's a serious question as to whether objectively an attorney might feel without a directive by this court, concerning the issue, or whether this was already an issue before this court, that should be raised. I would also, I see there's a
counsel, yeah. On that same issue or close to it, you said that it was trial tactics, which we know is always often an analysis for ineffective assistance, but the trial was over with. How was this trial tactics?
I think that's it's not a good shorthand for me to use. Rather than trial tactics, it's a judgment by counsel concerning how he's going to proceed with his client's representation. I was using the term trial tactics as just a shorthand for that entire concept. And I apologize, it turns out that was a bad umbrella term.
Okay, thank you.
So, yeah, however we choose to label it, it was still a decision by counsel, a judgment by counsel. And given the fact that what the Reagan-Tokes Act does is essentially for first and second degree felonies, it returns the state of Ohio to the previous indefinite sentencing scheme that Ohio had prior to Senate Bill 2 in 1996, when definite sentencing became the rule in Ohio. That given that fact, and given that Reagan-Tokes operates in very much the same way that pre-Senate Bill 2 law operated, that it may have been counsel's judgment based upon how everything had operated, and which had been constitutional at the time, that this may not have been a battle that was wise to fight. So, oh, I'm sorry, I thought there was a question and it doesn't look like there was one. So that was a judgment that counsel had made. Now, how that actually would prejudice Mr. Coleman is unclear. And that's not something that is my burden to respond to when it hasn't really been clarified. As far as the new trial motion, I do want to remind the court that what was essentially happening when Mr. Coleman made his own pro se motion for a new trial was he was attempting to engage in hybrid representation, which to date is not permitted in Ohio. Also regarding the witness CO, who was the second victim who was shot, his identity was known to counsel. His statements were available to counsel. You know, whether he chose or not to seek a subpoena of that person may again, and actually could have been an actual trial tactic or judgment. I would also remind the court that whether CO actually would have made a difference in this case is an open question. There is no actual guarantee or even necessarily a reasonable probability that his presence in the courtroom testifying that as he drove by and got shot, that he thought that maybe the person who shot him was wearing a black hoodie versus a green and blue hoodie, whether that would have actually made a difference in acquitting or convicting Mr. Coleman. Under the facts of the case, again, CO was shot while he was driving by. And it wasn't just the color of the hoodie that identified Mr. Coleman as the person who was the shooter that night. Both of the police officers testified that they saw Mr. Coleman as the shooter because they identified him as the shooter in open court. His DNA was on the portions of the firearm that were actually used by the person shooting, the trigger guard, the foregrip, and the trigger itself. So those all added up to help, and that's just the state's evidence to help to convince a jury that Mr. Coleman was the one who fired the shots. Then coupled with Mr. Coleman's testimony, which the jury had a right not to believe, given its internal inconsistencies, there's really no reasonable probability that had CO, that victim, been found and subpoenaed by either the state or Mr. Coleman, that his testimony would have made any difference in the outcome of this case. So there's really no meeting of the burden of showing prejudice. Finally, calling Mr. Coleman, as counsel puts it today, a bad witness, and pointing out that he had an interest in the outcome of this case, that I think reasonable lawyers can differ on how they read that. So I don't think that's objectively deficient performance, because you can also read pointing out that Mr. Coleman was a bad witness as an attempt at rehabilitating his testimony, to try to lessen the impact of him being a bad witness. Also, mentioning the interest in the outcome in the context, counsel was also talking about the interest that the police officers had in their testimony in this case. One of the things that he had done during cross-examination of both officers was to ask them about the testimony that they had given in hearings or in meetings concerning their use of force when they used their firearms in opposition to the shooter. So he was pointing out that those officers also had a vested interest in their testimony in this case, because they were subject to investigation themselves for their use of force. So in the context of the entire closing argument, another reasonable lawyer could also look at that as a trial strategy to try to minimize the damage that Mr. Coleman did with his own testimony to his own case, and also to call the credibility of the officers into question. Whether it was done artfully or not is not the issue. The fact that could be interpreted as a trial tactic with a specific purpose that did not intend to harm the client is another thing. Plus, again, given the entire context, did it actually prejudice Mr. Coleman? Given the evidence, probably not. So again, the burden has not been met. Otherwise, the state also disagrees, obviously, with Mr. Coleman regarding his first assignment of error regarding speedy trial, for all the reasons that the state has mentioned in its brief. And I'm not going to say for all the reasons we mentioned in our previous argument, because we're trying to keep these cases separate, but also regarding the manifest way of the evidence. Again, Mr. Coleman is the man who was seen firing the AK-47, by the police officers. He has gunshot residue on his hands. His DNA is found on the trigger guard, and the foregrip of the AK-47. And officers found that a person even double the age of Mr. Coleman was capable of running around the Summit Art Space building in the time that it took for them to turn around and see Mr. Coleman at the intersection and apprehend him. Could lead this jury reasonably to conclude, as it did, that Mr. Coleman was the shooter. So the jury did not lose its way and create a manifest miscarriage of justice by finding him guilty. Regarding the third, fourth, and fifth assignments of error, again, denial of the new trial motion, that was not an abuse of the trial court's discretion. And, the constitutionally Reagan-Tokes Act, I think we've discussed a little bit, although I am prepared to answer additional questions about that. Specifically, I would remind the court that the 8th District has found that scheme is constitutional, especially based on its being very congruent with pre-Senate Bill 2 law. And again, Mr. Coleman's counsel did not render ineffective assistance. And unless your honors have additional questions, the state would respectfully rest on its brief and ask this court to affirm.
All right, thank you. Judge Callahan, any further questions? Judge Carr?
Thank you.
Thank you, Attorney Corrigan. I've got 5 minutes for rebuttal, Attorney Kelly.
Unless any of you have any questions you'd like me to clarify for you, I think with that, I would rest on my brief for the rest of it.
All right, thank you. Judge Carr, opportunity for a question here. And Judge Callahan.
Okay, thank you.
Very good. Thank you both for your arguments here today. Once again, they were very good, so we appreciate that. We appreciate you appearing via Zoom as well. We'll take this case under advisement as well and issue a decision in due course. As you know, the clerk of courts mails the decisions to counsel on the day it's released, and the decisions are posted on the Supreme Court of Ohio's website.